Proceed to take up the case of Tribeca Asset Management versus Ancla International.
Good morning, Your Honors. May it please the Court, my name is Rebecca Placencia of Holland & Knight, and together with my partner, Adolfo Jimenez, we represent the petitioner, Tribeca Asset Management. I'd like to reserve 4 minutes for rebuttal. Your Honors, we're before the Court today on an opinion from the 3rd District Court of Appeal that holds that a plain and unambiguous choice of law provision can be converted into a form selection clause to confer personal jurisdiction over an objecting defendant without any further analysis as to whether due process is satisfied. And therein lies the source of this Court's conflict jurisdiction, because the 3rd DCA's opinion is in express and direct conflict with decisions out of the 4th DCA, the Hamilton versus Hamilton and the Ware versus Citrix Systems cases, that hold that even if you have a form selection or consent to jurisdiction clause, which we don't have here, but even if you did, you still have to undergo a due process analysis. Second, the 3rd DCA's opinion conflicts with clear law in Florida that a choice of law provision by itself cannot confer personal jurisdiction. And we filed a notice of supplemental authority of a Burke Products versus Access Electronics case, 2nd DCA, that also stands for that proposition. Finally, the 3rd DCA has determined that this clause, which does not specifically refer to where the seat of arbitration will take place, is a form selection clause, when the very definition of a form selection clause is that it selects a form. It identifies a form in which these disputes are going to be resolved. So for all these reasons, this Court does have jurisdiction. And now on to the merits. The 3rd DCA opinion has to be quashed. The interpretation of this contract in this case violates the plain and unambiguous language of the contract. And it creates a dangerous precedent, because it's basically creating a jurisdictional hook from a choice of law clause when that is not the law. If we do not actually select a forum, if you do not actually consent to jurisdiction in a particular forum, that is not enough to confer personal jurisdiction over an objecting defendant. Nowhere in our jurisprudence is there a case that holds that a choice of law provision by itself is sufficient to confer personal jurisdiction. What we have is a provision that says this agreement shall be governed by the laws of the state of Florida. Now, 3 sentences follow this choice of law clause, dealing with how to handle any differences that arise. And the 4th sentence following this clause, 4 sentences after the choice of law provision, says, and if you can't resolve your disputes, we'll resolve them in an arbitration board.
Counsel, I'm sorry to interrupt you. So assuming we agree with you on that, what would be the right thing for us to do at that point?
To quash the 3rd DCA's decision and to reinstate the trial court's decision, because the trial court said there's no venue.
And just stop the analysis at that.
You stop the analysis at that point, because if you don't have a form selection clause or a consent to jurisdiction clause, that's it, it's over.
So we don't need to get into the other stuff.
You just reinstate the trial court's decision and the case is over.
Okay.
Now, the greater question, of course, is what if you do have a valid form selection clause or a consent to jurisdiction clause? And we're not saying that you can't contractually agree to that. If you've got 2 parties who have signed an agreement, who have voluntarily, with informed consent, entered into this, that's a different story. You still have to do a due process analysis, because that's what the law says. Even section 685.102, even when the Florida legislature said, we're going to create a jurisdictional hook that parties can agree by contract, it still says you can't violate the U.S. Constitution. There still has to be some due process analysis, contained. And what the 3rd DCA did here, besides improperly converting this into a form selection clause, they didn't even bother with the fact that it was undisputed that Tribeca had no minimum contacts with the forum. In addition to the fact Tribeca isn't even a signatory, so we didn't even get to the first issue as to whether this was a freely negotiated clause between these parties, because Tribeca wasn't a signatory. That itself would have to be established before you can then go into an analysis of the due process. So to be frank, the 3rd DCA just tortured this clause to create a form selection clause where none existed. And frankly, Your Honor, I think it's a pretty clear case based on the plain and unambiguous language of the contract. Unless this court has further questions, I'll reserve the rest of my time for rebuttal.
May it please the court, Carlos Sardi on behalf of Ancla International SA. It's a pleasure to be before you for the very first time, and I feel very welcome. Thank you so much. Let's get now to the argument here for a second. It appears that, or at least it seems to me, that what Tribeca is intending to do before you here today is to have an appeal all over again of what the third DCA already determined. Essentially, its own factual de novo interpretation of this contractual language. Their so-called conflict, it's non-existent. We are not traveling under the long-arm statute. We're not traveling even under the Chapter 685 statute or body of law regarding generally contracts. We're traveling under a very specific statute, very much favored by this court in terms of arbitration and the arbitrability of cases in which parties have negotiated freely and voluntarily to arbitrate a matter. This is precisely what happened in this case. In the court below, there were a couple of conflicting affidavits, both of which were weighed and under which the trial court erroneously took the position that only one of the affidavits held the truth, position on a dismissal. So I want you to keep in mind that dismissal of this case had already been heard at the first instance, and an order denying that dismissal. Second time upon which the court heard dismissal was just at the heels of an evidentiary hearing upon which the petition to compel was going to be heard by the court with evidence that both parties were ready and prepared to put on forward. So, court cut off that hearing, essentially taking a position that it could rule on summary judgment, essentially, and try to dispose of the personal jurisdiction issue which had been preserved by way of an affirmative defense, and at that time, without any evidence, contradicting affidavits, ruled on the personal jurisdiction, committing an extensive error by having done so and not allowing evidence to come forward. Despite that, the third DCA correctly took a review, a de novo review, and decided on a de novo review that when you take a look at the particular clause here, which is extensive, looks extensive in nature, 144 words, my esteemed opponent only looks at 13 of those words to make her arguments, whereas the third DCA, in correctly interpreting that particular contractual provision, took a look at the whole provision to try to give it meaning, to see what the parties actually had agreed. What my esteemed opponent is saying is basically disregard the portion of that agreement that reads, a jurisdiction accepted by the parties.
Well, but counsel, I mean, the language starts off, obviously we have to look at this all in context, right?
Understood.
We concede that. But it seems that the table is really set for what this is doing in the first part of that sentence, where this agreement will be governed by the laws of the state of Florida. And that what follows that is understood in the context of that. Now, that's not to say that things couldn't be said after a sentence, a reference to being governed by the laws of the state of Florida, that would go beyond that. But it seems like here that the use of the term jurisdiction is just kind of describing Florida, the state of Florida. It is used in the sense that Florida is a jurisdiction and that the governing of the laws of the state of Florida is something that's accepted by the parties. So what am I missing when I look at it that way?
Well, it's all about just one word, Your Honor. What does jurisdiction mean?
In context.
In context within this particular proviso. In doing so, the third DCA, just like we had suggested in our briefings to the third DCA, took a look at the definition of that word to assist that court in interpreting the provision. And in doing so, and looking at the Black's Law definition of the term jurisdiction.
Well, but I understand what you're saying, but that's only one definition of jurisdiction, and that's the jurisdiction that supports their conclusion. But there are other definitions of jurisdiction, namely that cut the other way.
Absolutely,
And I
Your
can
Honor.
look them up. I mean, I think you know those others are in the dictionary.
But I think within the context of what the third DCA had attempted to do at our insistence in terms of utilizing a definition was precisely to give context to the whole provision. And as Your Honor correctly points out, there's more than one definition. That's precisely why you need to kind of look at the whole context and see what the jurisdiction actually meant. I'm sorry, Your Honor, I can barely hear you. Yes, sir. Well, if I'm understanding correctly your question, if we're only referring to just the law itself, I lose. But if we're referring as to the venue, I stand on my two legs here, and I think that the third DCA does as well. Term jurisdiction here, when looked upon the qualifier, which is Florida, they want you to look at the qualifier as being laws, the term laws within the proviso. But it's really Florida. Florida is the jurisdiction that the parties agreed to. That's what the third DCA concluded in interpreting the term jurisdiction within this proviso. To give it sense, obviously you need to continue reading the whole 144 words contained within it so that you can determine that Florida is where the arbitration is to take place. The title is applicable law, but as Your Honor well knows, the title in itself is not dispositive in a question like this. In my humble opinion, Your Honor, and of course you can form a different opinion, you're free to do so. In my humble opinion, the term jurisdiction here, without reference obviously to the headings, if we were to reference every heading in every contract, then we would be lost with the substance of what the contract is really trying to do. But if we were to just look in isolation, the word jurisdiction in terms of the whole substantive part of the section, I can honestly conclude, Your Honor, that what we're talking about here is not only the location, but also the power of the courts within that location, which is what the third DCA concluded. One of the definitions, obviously, of jurisdiction is that power of the courts. That's what should not surprise you to be hailed into the court of Florida. Now, if I may continue with my argument, the so-called conflict that we have with the third DCA, it's non-existent. There's a recent case that we have cited in our papers that came out in July of last year by that same court, the fourth DCA, in which the fourth DCA treating Chapter 685 within the context of the provisions of that separate statute, which is more generally geared to contracts, it cannot. All those cases are in opposite. All those cases are in opposite, Your Honor. If you take a look at the particular statute that we're traveling under, all you need to prove in order to gain personal jurisdiction over a defendant is comply with two things. One, that the proviso calls for the application of the laws of Florida. That's not an issue here. Two, that the agreement provides for arbitration in Florida. It's our position that the arbitration clause here calls for arbitration here in Florida. When you comply with those two things, much like in the back case that we have cited to your, in our papers, concludes that when you comply with the particular provisions of a statute, such as the ones in Chapter 685, which is what WARE is all about, then personal jurisdiction is had on a dismissal posture, and so that's how you reconcile Hamilton, WARE, and you have to take a look at BAC. In fact, BAC cites to Burger King, which is the seminal case dealing with jurisdiction and compliance with jurisdiction in terms of due process, constitutional due process. And even in that scenario, Burger King recognizes that the parties to a contract can expressly or impliedly waive personal jurisdiction. Based on that, the BAC case of the fourth DCA concluded you have personal jurisdiction as long as you meet the requirements of the statute. Once you have that requirement met, you need not go into minimum contacts or any of that analysis. Now, so that's why we're saying that this court should actually discharge its exercise of jurisdiction in this case. There is really no conflict between the cases that are cited by my esteemed opponent, and that the court affirm fully the third district court opinion in all its terms. However, if the court is inclined not to do so, then there are many questions that obviously were never dealt with at that very brief hearing prior to the evidentiary hearing where the parties were about to duke it out. And we would suggest that if the court is inclined to exercise its jurisdiction, re-examine the whole record de novo, that if it concludes that it would quash the third DCA opinion, that it should send then the parties back for an evidentiary hearing to conduct a minimum context analysis, number one, and this argument that supposedly their own agent did not sign this agreement. There is simply no reason to believe on the record here that the agent, when looking at the four corners of our complaint, that the agent did not sign on behalf of its principal. And that's what we have argued below.
Let me make sure I understand. If we quash and remand, what else needs to be done at the trial court level?
Well, Your Honor, then we need to have our day in court. Then Ancla's own due process will be truncated if we do not have an ability to prove up personal jurisdiction, number one.
I thought the trial court made a ruling that there was no personal jurisdiction and dismissed the case. Is that not right? The trial court did that, but what we're suggesting is that that was in error based on the conflicting affidavits that we had. And the third DCA basically, by issuing its opinion, cured that error. It did cure the error. And so our position is that if you're inclined to send this back, then we should all have our day in court and be able to determine what needs to be determined according to your own de novo review. Unless you all have any other questions for me, I would reserve whatever time you might want to yield to me. I don't know if I'm over my time. I'm not really looking at the clock, and I apologize.
You've got 5 minutes left, but you don't have to take it.
Okay, very well.
But if you sit down now, you're done.
That's right, Your Honor. Then I'll sit down now. Thank you so much for your time. I appreciate, again, your welcoming to your prestigious court. Thank you.
Thank you, counsel.
Counsel, would you mind addressing the argument that there is actually no conflict with the cases?
Absolutely, Your Honor. We do have conflict because, as this court held last year in Cartsonis, you can have express and direct conflict where you have the application of a rule of law with substantially the same controlling facts that leads to different results. So what the third DCA did here was say, hey, I'm going to convert this. This is going to be a form selection clause. There's no need to go any further. Whereas the fourth DCA in both Hamilton versus Hamilton and Ware versus Citrix says, okay, we have a form selection clause or a consent to jurisdiction clause, but we do need to go further and we need to see if there's due process because you cannot go beyond, you can't just skip this process. In fact, it's written directly into the consent to jurisdiction statute that it cannot violate the US Constitution. Correct. That's exactly right. Where the jurisdictional hook is based out of a contractual provision, you always need to have a due process analysis. Now, maybe it's not the traditional minimum context where you have a tort claim and it's just somebody have sufficient minimum context. It's a different analysis, of course, because we're in a commercial context. So you'd have to do an application of, are these the parties who agreed to this? Was there informed consent? Is this a freely negotiated clause? Because, okay, then you could argue purposeful availment to satisfy due process. Or is the enforcement unreasonable or unjust? Now, that might be...
I'm sorry to interrupt you, but so if we, though, decide this at the threshold that the court was wrong and that this is just a choice of law provision, does that affect our jurisdiction, though? I mean, because then we're not resolving I mean, at that point, then we're not doing anything on a conflict.
Well, you actually still are, because the second DCA in Burke Products said a choice of law provision by itself is insufficient to confer personal jurisdiction. So you'd still have a conflict on that ground.
Okay.
Because what the third DCA did here was basically say, well, here's a choice of law provision, we're converting this, and you have jurisdiction just based on this alone.
But the third DCA didn't rule on whether a choice of law provision, because they didn't think it was a choice of law provision.
True, but they're still saying you have a contractual provision. So that alone is grounds for a conflict, because we've got now Burke Products out of the second DCA, Hamilton and Ware out of the fourth DCA saying a contractual provision by itself is insufficient. In fact, that's what the Florida statute says. And whether this is the arbitration statute, as my esteemed colleague is arguing, or a consent to jurisdiction clause under section 685.105 is a distinction without difference. The point is, do you have a contractual provision that by itself can confer personal jurisdiction without due process? And the answer is no. The law is clear on that.
It's an odd jurisdictional thing, right? Because you're arguing that there's a conflict, but the conflict exists because of the erroneous interpretation of the contract by the third. And once you remove that, you're arguing, then you've resolved the conflict that wouldn't exist anymore in the law by a correct interpretation of the contract.
That's true. The third DCA, in interpreting it this way, created the conflict.
Let me ask you about the argument that if we were to quash the opinion that there's still something left to be done at the trial court level. Do you agree with that?
No. If you quash the opinion, then the trial court's order is there's no choice of law clause. I mean, this is a choice of law clause and that's it. And it was undisputed that there was no minimum context. The analysis is over because a choice of law clause cannot confer personal jurisdiction. It's done.
Was there the determination by the trial court that there was no personal jurisdiction? Is that still at issue?
I mean, they're arguing that it is, but we argue that it is not because it was undisputed. Ancla's attorneys never disputed the lack of minimum context. Their argument below was always, we don't need minimum context because you signed a form selection clause. And the trial judge said, forum venue isn't even discussed here. This is just a choice of law clause. So if it's undisputed that there are no minimum contacts, I can't exercise personal jurisdiction.
There was not a dispute about sufficient contacts to establish venue in a normal sort of way without the use of a statute.
Correct. There was none of that. It was undisputed. Now, they argued here that, well, there were affidavits. At no point during the hearing was there any reference to an affidavit. At nowhere in the trial court's order or in the subsequent order for rehearing does the trial judge refer at all to the affidavits. So there was no factual analysis being done by the trial judge here to determine minimum contacts because they had already conceded that Tribeca didn't have minimum contacts. So the trial judge is saying, I've got a choice of law provision and no minimum contacts. I can't exercise personal jurisdiction here. This is clear. Unless this court has any further questions, I rest on my briefs. Thank you, Your Honors.
All right, we thank you both